Hello, this is Curt Pringle, and thank you for tuning in to the Talking Issues series, where we talk about public policy issues. And today I'm really excited to have a longtime friend, but someone who has such a broad experience in the law and really how the law works. Someone who's experienced that position from a private sector attorney, one of the most prominent attorneys in all of Orange County, to the federal courts, where he served on the bench, an appointee of the president, and served here in Orange County on the federal court bench. So my friend is Andy Guilford. Glad you're here, Judge Guilford.
Pleasure to be here and talk with you.
It's great. Well, we all know, and we don't need to get into too many stories at the front, but you and I first met when the City of Anaheim hired you as an attorney. At the time, the Angels changed their name, and the City of Anaheim chose to address that issue legally. And you did a wonderful job in that court case, but we both lost, and that was a sad part of that issue.
Well, I have to first of all commend you for fighting it. I think as a citizen of Orange County, a fight needed to be made. And I've looked back on that case, and I feel bad. I've told you I think it's the only negative thing that happened in your term as mayor. But it was worth the fight, and the settlement offers that were coming were such that you had to fight. They were making way too low settlement offers.
Yes.
So the city council would not have approved, and you would not have approved, and they forced us into the litigation.
But you see, that is how we met, but that's not how our relationship grew, and my admiration of you grew from that point, because that was your last case as a practicing lawyer in Orange County?
Yes. When the Orange County jury came back, and in a very close call, after they had been turned from being in our favor, and decided that the name of the team would have LA in it, I said, Andy, trial attorney, you have to change jobs. I actually got a phone call from the White House while the trial was going.
No,
I'll change jobs.
Isn't that something? I mean, in the middle of this trial, a very public trial, a very challenging issue, of course, you get a call from the White House to say, we'd like to appoint you to the federal bench in Orange County.
That's the way it came down.
Isn't that something?
So
what is the job of being a federal judge overseeing federal cases in a county like Orange? What is that job?
I took an oath of God to protect the Constitution, so let's start with that.
All right. Wherever you want to start, it's written on your tie, I see.
Yeah, it says right here.
Yeah, exactly. And at your age, I don't think you can read that either.
No, it is to apply federal law in Orange County. You know, we have state law and we have federal law, and federal courts are there to provide a place to resolve disputes over federal law. And then there's something called diversity jurisdiction, where we get some state law too, but it's mainly federal law. And these days, in fact, all days, if you open the newspaper, you will see issues of federal law throughout, and they continue in the past and into the future. So I would be applying federal law and also federal crimes. I would have federal criminal defendants and other cases involving federal law. Big thing for me was patent law. I do think Orange County is a technological powerhouse in the United States, and that means patent laws are important. And to me, I thought that companies in Orange County needed to have a good patent court.
Yeah, isn't that funny? I didn't really know that was one area of interest you had or knowledge. And at that same time, I believe another Orange County resident, our mutual friend, Jim Rogan, former member of Congress, my former roommate, as he and I both served in the state assembly together, and he was appointed by President Bush to head the Patent and Trademark Office. And at generally the same time, I think at the same time you were appointed.
Yes.
He was also nominated for the position of federal judgeship.
And I was really hoping I would get him as a colleague on the federal bench. He did a fine job on the state court bench, but gosh, to have him and his expertise, particularly in areas like patent law, sitting on the federal bench would have been tremendous.
Yeah.
I didn't get that chance.
So what is that process? So the president and his team appoint people across the country to these federal judge positions, and courts of appeal, and of course, Supreme Court. All of those positions are within that judicial realm. And so you get a call, you're nominated, you're appointed.
Well, first they call you before they nominate you. They interview to see if you'll.
I'm sure they fleshed you out for a while.
There was a lot of fleshing out and some fascinating interviews at the White House. And in the process, I thought, even if you don't get this, it's just so much fun.
Yes.
And when I was up for the district court, which is the trial court, a guy named John Roberts was also up for the Supreme Court. And the guy who was handling me was also handling John Roberts. And for some reason, they were paying more attention to his nomination than mine.
Exactly.
So I was sitting in the office of the guy handling me. I had flown all the way back, on my dime, and the phone rings. I'm thinking, you're not going to pick up that phone. They're talking to me. He picked up the phone, and he talked a little bit, and he says, John, I have to go. And he hung up, and he said, that was John Roberts. And I thought, gosh, I'm touching history here. A fascinating process. The questions they ask, what's the 3 worst cases you've ever heard of, and the political implications. Fascinating time. And it ended up working out. I went back 3 other times for appointment to the Ninth Circuit and failed them all. But it was still very, very interesting. And it's quite a process.
So let people know what. So just because someone out there said this guy, Andy Guilford from Orange County, would be a good federal judge, all the vetting that's required to take place to make sure were your neighbors interviewed?
Oh my gosh. The FBI goes knocking on each of my neighbors' doors, leading them to wonder, what's going on in the Guilford household?
Yes.
And they're very FBI and very straight-laced and didn't tell why. So my wife had to go around and thank them and had a little gift for them and explain why they were asking about Guilford. Yeah, they do interview neighbors. Oh my goodness. And they wanted a reference from every residence I had been in. So, if I had lived in 6 different places.
See if you trashed the house or
all that.
Yeah.
Ex-girlfriends.
I see.
Ex-girlfriends. So treat your boyfriends and girlfriends well, because they might get asked by the FBI. And, I was wondering, now, what would she say about me? So it is pretty thorough. It got much more thorough after the Ginsburg affair. I don't know if you remember, but there was a guy named Ginsburg, not Ruth Bader, but the gentleman, good libertarian. And it went through all the vetting, and it came clean. And then Nina Totenberg decided he was teaching at Harvard. I bet he smoked dope. And she burrowed in and found out he had smoked dope, and that disqualified him. So, yeah, they ask a lot of questions back then. Maybe
so you're referencing your age when you say dope, just so you know. There's probably other things you could say to be hipper, but that's good.
Yeah,
that's good.
Did that on purpose.
Yeah.
But another thing, I got to say, in the process, they ask you questions. I'm sitting there with Al Gonzalez, the Attorney General of the United States, and he says, please, everyone, leave the room. Mr. Guilford and I are going to talk. And he leans over to me and says, have you ever used an illegal drug? Look, I was a child of the 60s, born in 1950. And I'm grateful to my father, who put the fear of God in me such that I had never used an illegal drug. I could look him in the eye and say, no, sir. Then he asked, have you ever had an affair? They asked these questions.
And the Attorney General asks you. The Attorney
General is asking me if I have an affair. So it was pretty thorough. And then there was a question, have you ever had psychological counseling aside from marriage counseling? I guess I answered them all correctly. That one bothered me a little bit because
now wasn't there another appointee that?
There was the vice presidential candidate.
Oh, that's right.
Remember, Eagleton.
Yes. Right.
So all of these questions have historical roots and all. But I had thought, if my father had died and I went to and my daughter now is a psychologist, I don't think I don't think we should discourage people from seeking psychological.
Well, I mean, that's a whole other topic on, mental health and how acceptable the conversation is today, as it was so challenging in the past to even reference the fact you see a psychiatrist.
Indeed, and I think we've come a long way on the psychological question. Frankly, in the middle of the Bush administration, they changed from have you ever used illegal drugs to since college, if you ever used a legal
Oh, is that right?
And then along came our President Obama, who wrote a book that said he was pretty big into cocaine.
Right.
I shouldn't say pretty big. He had used cocaine.
Right.
So, it's all developing. I think it's much looser now, for good or ill.
So on then the confirmation process, you go through this vetting, you have your name advanced. There are some inside steps that were necessary before you would advance to the Senate for a vote, right?
Indeed. Yes. More vetting, more questions, more side questions. One of the people doing the vetting said that he never asked the Roe versus Wade question. Well, he asked me the Roe versus Wade question, which is difficult when you're appealing to both sides and you've got two Democratic senators. And I had to get the approval of the two Democratic
See, that
senators.
is what some people may not be aware of. Back in the Bush administration, there was an official or unofficial deal
Oh,
with the
yes.
Senate?
Since we had two Democratic senators, and you need the approval of both senators, generally speaking, President Bush
For even the ability to advance a name to be
Yes.
appointed to the
So
the
they
federal
went through all
court.
that process,
I
and
see.
I needed to get the approval of both Democratic senators before I went to the president. We can debate that system. It does tend to push towards moderates, which may or may not be a good thing, but it made it difficult to answer a question with three Democrats there and three Republicans here and make them all happy.
Right.
I guess I managed to pull that off.
So that was the deal, mainly because President Bush had a Democrat Senate.
Yes.
And do you want any of your nominees even to advance for a
Yes.
vote, and therefore make a deal so you at least are
Yes.
consistent? So some people would argue, since California had two Democrat senators since John Seymour left the
Seymour.
position, filling Pete Wilson's position in the U.S. Senate for California, that it might be one of the reasons why California appointees may have been drifting a little towards the moderate left-leaning position. So
Indeed.
a good guy like you still had to have that approval for those two Democrat senators.
Yes. And then you have to appear before the Senate Judiciary Committee and finally a vote of the Senate. Senate Judiciary Committee was fascinating. All the senators
Yes.
lined up asking you questions. And at that time, they were much more concerned with this Roberts guy. I don't know whatever happened to
Oh,
him.
good. So
They
your
had-
advice is to follow in the shadow as a stalking horse behind
Yeah.
maybe some more significant
Yes.
appointment.
I got very few questions. I got one from Lindsey Graham, I have to say. He said, Mr. Guilford, you're from a big firm. Yes. You're making lots of money. Yes. Turn to my wife sitting next to Mrs. Guilford. Yes. Hudson's been making lots of money. Yes. You realize as a judge, you'll be making substantially less money. And of course, I earnestly said, yes, we're prepared to make less money and serve our country. And he said, so you won't be coming back in a year asking that we increase judges' salary. And I always thought that was a clever argument. And I never asked for an increase in salary, and I was happy to serve.
Oh, that's good. So what was the salary?
200.
200.
That's 200,000. And I'm the son of my beloved father, a bus driver, and I think judges and others forget what 200,000 is,
Right.
or at least was in 2006. And I thought it was pretty graceless to ask people to support you for the position and then a year later be asking that it be raised and not understanding that to most Americans 200 is just quite fine.
Right. To
So-
this day, not, and you're referencing almost 20 years ago.
Yes. I will say, when I retired, my salary was fixed and I don't get COLA. So I am getting my salary as it was in 2020 with no COLA. I'm on a fixed income and an enemy of inflation. But that's another thing.
Exactly. Another thing, and we won't talk about any more issues relating to your wage and salary benefits. So, so you're appointed to the federal bench. You get approved by the U.S. Senate. That's kind of a cool thing.
Yeah. It was 93 to nothing, actually, partly
Really?
because of this system of
Right.
if you get out of the committee, you're going to get the approval. I always thought 92 to 1 would be more impressive because it would show someone gave it thought.
Well, there are
I'll take-
7 that didn't want to vote for you. Let's put it that way. So
Yeah, we're
we'll work it that way. So,
Yeah.
so what is the job sitting on the bench? I mean, like how many cases come before you in a year? How long are they? And how diverse are they? Are you pigeonholed into a certain area of service?
No, every federal judge hears every case, every kind of case, and the cases just keep coming in and dealed out to all federal judges. The extent of my caseload is based in part on how many federal judges we have, which is based in part on are we getting appointments to people who retire. During the Trump years, they weren't getting appointments out of California because the senators weren't approving Trump candidates. So the caseload really started to increase because people would retire and they wouldn't get replaced. So at the end, I had, maybe 350 civil cases and 100 and so criminal cases. And the civil cases are all kinds: securities, patent, wage and hour, labor, employment, discrimination, civil rights. And the criminal cases were federal crimes. And so, the case is pending and there's lots of motions, shall we dismiss it on summary judgment or shall we provide them more discovery? And you go through all the motion practice and then comes the day for trial. And only about 5% go to trial, 95% settle. People kind of forget that. In law school, I learned all about trying a case. I should have been learning about settling a case.
Right.
90 to 95% of cases settled. Get a lot of wage and hour cases, class actions, a wide variety of cases, which required a lot of learning to the extent that wasn't part of my practice. Like I wasn't a criminal lawyer, but I think I picked up on that.
Yeah,
I looked at my first case.
I looked at some of your various cases along the line, and you have addressed some that have Orange County specific focus. For example, no, I'm not going to say what you think I'm going to say. For example, a lawsuit by Carl's Jr. against Jack in the Box.
Yeah, so that was a trademark case. An interesting case. Hamburger companies have a lot of funny advertising, and there was an advertising put out by Jack in the Box with the guy with the round head.
Jack, yeah.
And the implication was that Carl's Jr. meat comes from the Agnes part of the cow. With the look over the shoulder at a picture of a cow at the rear end part of the cow. It's a joke. Agnes is actually a breed of cattle, not a portion of the cow.
But Carl's was suing because it was ridicule. Jack in the Box was ridiculing their advertisement.
As I think, as my opinion cleverly said, there's an issue about how clever judges should be.
Yes.
Carl's Jr. didn't want to be the butt of the joke.
Yes.
So I actually wrote that and debated whether that was deserving.
And that actually is in your decision on the case, of which is in my papers right here that I read. You wanted to, I think you also referenced the quote, "Where's the beef?"
Where's the beef?
Which I was trying to figure out where Wendy's was involved in that discussion. But
now that is true. So you're doing it yourself.
Are infringing upon their trademark, I believe. But anyway, we won't go there. But I just referenced that because deciding between two big companies about how one advertisement may make fun of another company elevates itself all the way up to a federal judge to hear the case and to make a decision.
They made a federal case out of it.
Exactly.
And it's because trademark is largely federal law.
Yeah.
The law protects trademark. And actually, as I think back, when I was a little bit humorous, it was partly because I thought, really, guys, it's a joke and get over yourself.
Right.
And I ultimately decided the case that the people weren't confused.
Right.
The survey evidence did not indicate someone actually thought Carl's Jr. meat came from that part of the cow. And so that's why I dismissed the case. But the jokes came from, come on, guys, it's a joke. I'm having fun. You're having fun.
Right.
I don't know why you brought the lawsuit, but I can't.
Well, but a lot of lawyers made a lot of money from two big companies.
Well, I'm not cynical about lawyers.
Oh, sorry.
And it's true.
Right.
I must say, when I was a lawyer, I bristled a little bit about that. After many, many years as a judge, let's just say I bristle less.
Yeah.
A lot of that goes out. But you do have to remember,
right,
to get business, you got to make the client happy. And a lot of people have the view that corporations are just loving to spend hordes of unnecessary dollars on attorneys. They aren't if it's repeat business. it's an important point. I mean, you want to get closer in your back as a client. If it's a fender bender, that's not repeat business. It's interesting, the dynamics of billing, and there's some truth to the fact that there's overbilling, which is hurting the American economy, which is disturbing me.
Yes. Well, I don't know how well you're disturbed by those things, but
Well, let me just say, for many years, I sent you bills that the city had to pay. So,
right.
and I think you had a duty to represent the interests of the city. So
Yes.
we worked it out.
And I think we can contain them, but we won't, again, get into that matter. I mean, I don't want that percolating through all the discussion. But also, you presided over a much more serious Orange County case, and that dealt with our former sheriff. Right?
Indeed.
Yeah.
Criminal case. I was pretty new to the criminal calendar.
Yeah.
Talk about active attorneys. I got dozens and dozens and dozens of motions, and ruled on them all.
Right. Referencing the cases, federal cases revolving around Sheriff Mike Corona.
Indeed. And an important case and an important role for the courts to play, somewhat being replicated on the scene these days. I see things going on with certain government officials or former government officials, and I compare it to how I handled that case. But the bottom line is the importance of the court in resolving these political disputes. And some people are skeptical about what the future is, and forgive me for just putting in a plug for courts. The courts will always protect us. The Constitution will protect us. And the courts have shown themselves pretty worthy of taking tough decisions against officials while being fair to the officials. I could go on and on. But
yeah, but see, I think you hit a really important point, and because it touches both sides of the political aisle. So it's not Republicans are good and the Democrats are bad, or Democrats are good and Republicans are bad. And yet it seems at certain points in time, those that are on one side feel that the courts are lined up against them. And so I don't know. Do you think there's been a time in history where people have been more down or upset with the court system, or viewing it as an impartial or a partial, body in resolving disputes? I mean, is this kind of a heightened point in time on those questions people have of the court's neutrality?
It may be heightened, but let me tell you, I remember Andrew Jackson had a decision.
You personally remember that?
We have the same first name.
Yes, okay.
But I looked it up.
Okay.
I did look it up. And he said, the court has made its order, now let us enforce it. And kind of presidentially saying, who cares about the Supreme Court? And that has continued on through the years. And, there was the Earl Warren Court, which greatly expanded areas of civil rights and criminal rights. And maybe you're too young. There was an impeachment effort against Earl Warren. We haven't had an impeachment effort since that I can recall. So it was pretty serious back then. But I think over the years, even beginning in the Earl Warren Court, the courts have become more political. And people are learning, if I can't get it in the legislature, I'll go to the courts and get it.
So courts have become more political.
Making political decisions. Actually, that needs clarifications. A political tool to get what you want.
I see.
With the notion that some who are failing in the legislature may come to the court and seek relief in the court. Now, let me say, an example is Brown versus Board of Education. The legislature, particularly in the South, wasn't providing the relief that I think was absolutely needed. And thank God our Supreme Court thought it was absolutely needed and gave us Brown versus Board of Education. So there was this growing trend. I mean, think of the issues we've had from gay marriage to abortion to a million other issues. The courts have become more central in the political process, I should say. And courts have tried to step back from the political process and done a pretty good job, but I think that has thrust them into public awareness from both sides. I mean, the right was very upset with Earl Warren, and the left is very upset now.
But I'll even draw it closer. I mean, I can recall within my political awareness, actually at the times of my political service, there were so many people on the right that were saying the activist courts are writing legislation or directing things beyond what legislative authority was a part of the law itself. and therefore there was a liberal activism within the courts. I don't know if that was universal or there, but it certainly was the statement people had. Whereas today, they look at the Supreme Court, and you have a high number of Republican appointees on the, U.S. Supreme Court, and therefore the liberals, the Democrats feel that it's an unfair balance. So, I mean, you almost can see within a 10, 20-year time frame that both sides feel that they're disadvantaged.
I agree with that. And if I may make a comment, which perhaps shows my cards a little bit, but maybe not. We had a conservative Supreme Court in the 30s, and FDR wanted to stack the courts. The famous phrase, a switch in time saved 9. The Supreme Court, under the threat of the presidential action, started to get a little more liberal on New Deal policies called Lochnerism, et cetera, et cetera. The point I'm making is that was a conservative court. And I do say to friends, and I invite challenges, get a hold of me and tell me, the court has been liberal ever since until the latest round of appointments. Mm-hmm. And I think that's fair. I mean, we had the Earl Warren Court, lots of Republicans, but still they gave us a lot of liberal decisions. We had the Burger Court. We had Roe versus Wade. We had a lot of liberal decisions coming up even to the fairly recent court decision on gay marriage and LGBTQ rights. And let me just say, I think it's been pretty clearly a liberal court. So I would ask those. First, I'd ask them to correct me where I'm wrong, but I would ask them, 1930 to 2020 do the math, isn't 80 years enough for a liberal court? Could maybe we have a conservative court for a while? Isn't that part of the democratic process? So I wonder what people have to say about that. And then also, I've done a list of justices who have turned against their party in a major case. Sandra Day O'Connor supported abortion in Planned Parenthood versus Casey. Sandra Day O'Connor did that. I could go on and on about Kennedy and Souter and John Paul Stevens and Warren Burger, the number of Republicans who have turned against their party in major cases. And I'm trying to put together a similar list of Democrats who have turned against their party in major cases. And I don't want to challenge you, but I find people don't give me as many Democratic justices. That is to say that this notion of a lockstep Republican plot is belied by the number of Republicans appointees who go against the party. And I actually think that's a result of a commitment to textualism. I hope I'm not getting too controversial here.
Well, I'll shut you up when you do, so keep going.
Okay, so textualism. As a judge, gosh, I saw crazy laws. I saw crazy laws from the right. I saw crazy laws from the left. And it's a good chance if I kind of rule the way I wanted, I might get it by the Ninth Circuit. And that's not a good thing because we're a nation of laws. We follow the rule of law, not the rule of Andrew Guilford. And so I ask, how can I tether myself to honesty? How can I tether myself to honesty and not let my very creative mind go off on theories producing the result I wanted? Textualism allowed me to control.
Good. So give me a very tight definition of what textualism is.
Look first at the text and don't expand beyond the text if at all possible. Or find a text that supports your decision. Again, at the risk of being controversial, there is no right to privacy in the Constitution. Yeah. That word doesn't appear. And yet a whole lot of decisions have done a whole lot of stuff on a right to privacy. So a textualist might say it's not in the text.
And I'm not going to ask you this question, but would a textualist have said that it was all right to change the name of the Anaheim Angels to the Los Angeles Angels of Anaheim because the text of the lease did not specifically require Anaheim Angels to be the name?
And what case was that in?
Mm-hmm. No. Your last one, I think. No, we don't need that.
No, actually, it's a very, very important point. The words of that particular lease, for various reasons I won't bore people with, but they are Anaheim will be included in the name of the team. And the jury decided that Los Angeles Angels of Anaheim. Anaheim is included in the name of the team. So a totally committed textualist would say, there's the text, Anaheim loses. Others might look at what that means, or whether ever in the history of baseball there had ever been two, you know the word, geographic identifiers,
Yes.
the phrase. So an activist might say, well, those are the words, but everyone knows they didn't mean it.
So I have used that just to push back on
Indeed.
you in that regard, to really say that also what you're looking for is are there gray areas within even the textualist focus that in fact can you read in intent even though the words may not imply that?
Yes.
Oh, okay.
No,
No. For me, even to get you to not rip my face off in some of those things, because I know your intellect and your skill. So, thanks for playing along with me on
well,
that.
but let me expand it and make it actually maybe more accessible to people. A lot, you ask, what did I do as a district judge? I read words and applied the law.
Yeah.
But we do that in a lot of different areas. I read the words of the Constitution and apply the law. I read the words of a contract and apply the law. I read the words of a patent and apply the law. And I read the words of a statute, and it goes on and on. But here's one. Many of us read the words of Scripture and apply the law. Mm-hmm. There are similar things. Are we literalists / textualists? Do we look at what the world was like in 34 AD? Do we look at the history? Do we look at the intent? Can we say that can't possibly mean what it says? Anaheim will be included in the name of the team. Couldn't possibly mean the name of the team is Los Angeles Angels. So I've tried
just
to be
so you know, very, very good recovery. That's really good. You've done a fine job. I guess things change with time to a certain extent, but that intent is referenced. So when people look at a Supreme Court with 9 people sitting on it making decisions, and since the foundings of this country, the Senate has grown, the House has grown in pure numbers. So are you one that would support the Supreme Court growing in its numbers?
Almost absolutely not. Perhaps there could be some procedure, some time to adjust the court. And by the way, the Constitution does give quite a bit of power to do those adjustments. FDR's provision about packing the court was proper under the Constitution. It gave the Congress the power to do that. It ended up being politically unwise, and I praise the people of the 1930s who could see the unwisdom of it. To answer your question, though, most of the proposals are that the president in power will get the chance to throw the 3 more justices or 4 more justices onto the court. And that is totally inappropriate, as it was in FDR's day, and cost him political power. And I think now, people may not remember, but President Biden raised the possibility of packing in light of the right bend of the court. He appointed a commission. People may not remember, but the commission came back and said no. And there was a minority report that said, heck no. So it's still out there. President Biden has political cover saying, well, I appointed a committee. That's kind of sometimes what you do when you don't want to decide. And the committee's out there. And I think the packing of the court thing is diminished. But I do think that guy, John Roberts, who ultimately made it to the court, is concerned. And just like a switch in time saved 9, maybe he's thinking, gosh, I don't want to get too political on this because heaven knows there might be another court packing thing. That's a long answer, as lawyers are wont to do, to a simple question. I don't believe court packing is a wise decision because it almost always is presented in a way that hurts one side and helps the other.
Yeah, so when people look at the Supreme Court or the federal bench at all, one of the things that's unique there is the lifetime appointment context. Is that, first off, your appointment was a lifetime appointment?
Indeed, all federal judges.
And then your life came to an end in 2020. Is that what you said, or you chose to?
Interesting point. So lifetime appointments.
Yes.
No, my term didn't come to an end. I could have served until forever, until I was senile and beyond, unless someone brought an impeachment action against me. So that's actually a little scary, and maybe that's an area where some reform is needed.
Yeah.
But lifetime appointment, I support. Most state courts don't have it.
Right.
And I do see state court judges running campaigns, getting campaign contributions from people who might ultimately have an interest before the court. And I don't like that. And I think the founders were very wise in giving a lifetime appointment. When you think of it, we have the Constitution, we have the Bill of Rights. The Bill of Rights are 10 rules where the minority beats the majority. If the majority says take down that mosque, that's what the majority says. No, there's a minority right, First Amendment, where government's not going to take down a mosque. So the organization that does that is the Supreme Court, an organization that is regularly ruling against the majority in enforcing Bill of Rights, shouldn't be standing for election by that majority. So that, among other reasons, I think lifetime appointment is important. Another reason is when people retire, like I did, it's kind of unseemly for them to get back in the industry. And I've faced being accused of doing exactly that. What I mean is, what if in my last month as a judge, I made a decision that elevated abortion, elevated arbitration rights.
Right.
In my last week as a judge, stopped being a judge and became an arbitrator. Would people go, that doesn't sound right? So I'm saying two reasons for lifetime appointment. Everyone thinks one is the ability to rule against the majority. Another is, would rather have you sticking around as a judge and not taking up compromising positions afterwards in a non-judge position, which is what I've done. Sorry.
Yes. No.
I haven't taken compromising positions.
Thank you. I want to clarify that point, and I'll help you as your attorney. But so you left the federal bench with a very, very successful record in service to the county, but more importantly to the country. And now you've gone to work for an arbitration mediation firm.
Indeed, private company.
Yeah, and to hedge on that though, is that where legal disputes will go? Not to the courts, but I mean, I remember even a small claims action I had, and I was offered / pushed into going to a mediation or arbitration discussion. I mean, is that how you handle court processes now with the pressures on the court because of the volume of cases?
Yes, and in fact, you're kind of suggesting a free market / libertarian analysis. I once wrote an article saying, gosh, I get up in the morning and get on the toll roads because the government freeways are too crowded. I go through the gate for my private community because government isn't giving me parks and law enforcement. I drop my kids off at the private school because government isn't giving me a good school. I get to my glass high rise and go through a gate because the government isn't giving me police. I go up, sit down in my office and open up a demand for arbitration because the government isn't giving me a good court system. Some people think the government court system, like a lot of government things and like a lot of things that the government subsidizes our court system, it tends to be in short supply. And some might see arbitration as a free market alternative to government not keeping up with the demands. And to that extent, a lot of judges will celebrate it because it reduces their caseload. And of course, it only works in the market if people go there and pay extra dollars for something they could get largely for free from the government. It is a free market alternative to some shortcomings from the government. But I have to say, it's really important that we not just merge the two and be indifferent. And arbitration will never enforce Bill of Rights protection. We don't have that power. So there's still a very, very, very important role for judges who have the power to uphold the promises of the Constitution in a way an arbitrator cannot. So I can't do that anymore, but I can resolve disputes, usually between commercial people. Yes, I'm an arbitrator, and I'm also a mediator, which means I try and settle cases.
Yes, well, and I certainly appreciate all the service you provided, not only the people of Anaheim or Orange County or the country, but you have been such a significant player and someone I personally appreciate, and want to thank you for coming in today and sharing a little more in-depth discussion of the court system in this country.
It's great talking to you. You're too kind, but I love it.
Yes. Well, thank you, Judge Guilford.
Thank you.